What's up, man? It's Terry Henderson Peden of the Law Group of THP, a bona fide parole attorney and civil rights dragon slayer. Okay. Today I want to talk to y'all and give y'all some information on the early parole program in Alabama, and I want to go through the details and specifics of it. And below I'll have, in addition to our full office contact, if you want to give us a call, I will also attach the different links from the Alabama Code section, which is the law, the application for early parole form itself, and some links to the administrative rules that make up this program. So I know in one of our last videos, I talked to y'all about community corrections. That's a way in Alabama where a person can get out. And it has its own set of rules and requirements, and early parole has its own unique set as well. So a bit of background. I get a lot of calls about this program. I think that on paper it's a good thing, but whenever you get into the requirements of it and the exclusions, I don't want to be overly critical or cynical, but I do think it's a bit arcane and doesn't really achieve the purpose of something like you would assume an early parole program would be for, which is for generally people who might not be perfect because they're in prison. However, they've made a concerted effort over time to show themselves to have been rehabilitated and on the right track and no longer a threat to the public. So with that said, first things first. So with this application, say we go through all these steps and you make it, what this will allow you to do is basically move your current parole consideration date forward closer to the present date by up to 3 years. So if your present parole consideration date was for August of 2028, this would allow you to move it up to August of 2025 or whatever year it is. You get me? Okay, that's that. Also, if you have already went up for parole and been denied, then you have to wait 18 months from the time of your most recent denial before you can apply for early parole. Okay, so say you went up for parole in August of 2020 and they set you off by 5 years, right? Then you would have to wait 18 months, which is a year and a half from August of 2020 to be able to apply for early parole, okay? And then from that point, it would allow you to bring your consideration date, if you're approved for early parole, from 2025 up to 2022, right? So that allows you to cut out 3 years of that time off that 5-year set off. So if you have seen parole and you were denied, you have to wait 18 months from your denial or from your revocation to be able to bump your parole up forward. And if you have never seen parole and you have never been revoked, then you can apply for early parole once a year, okay? If you meet the requirements. Let me see. Now, with this, if you go on the Alabama parole website, which is paroles with an S, .alabama.gov, you go to the forms tab and you look at form number 1, application for early parole consideration. The overall thesis and mindset behind this, the logic behind it, is basically we're going to grant you early parole because it's more likely than not, more probable than not, that you would have been granted parole. Okay, so these requirements are supposed to show if a person is more likely than not to have been granted parole despite being set off or revoked. Okay. And the first requirement is the inmate must have served a minimum of 5 years on his or her sentence. So you gotta have served 5 years on your sentence. Second requirement, the inmate has completed any available evidence-based risk-reducing programming as recommended by the Department of Corrections after performing a risk and needs assessment. Okay, so you're taken into prison. They're supposed to class you up, put you through a risk assessment. Your ITP should reflect. Your ITP, which is your individualized treatment plan, should reflect what needs you have. If a person is a sex offender, then they're going to need probably some sex offender type of programs. If they're a drug addict, then they're going to need some drug programs and stuff. And if they're got a history of aggravated assault, you know what I mean, then they need to do something to address that pistol starting problem that they got. You know what I'm saying? So but I interpret that as your attorney. What I'm telling you is take every single program that you can. If you're sitting in prison and you're not programming or handling education and there's nothing stopping you, then you're wasting your time. You don't have to, even if you're in prison. You feel me? Because then that gives me, as your attorney, when you've been down there showing out in the positive way, that makes my job a lot easier than trying to justify why you've been twiddling your thumbs. You know what I mean? So do all the programs. Right? So requirement 2 has done all the programs. Requirement 3, inmate has received an official positive report from the Department of Corrections. So basically what that is a letter of support. Pretty much you can handle that or satisfy that by getting a work report or officer report from some correctional staff, somebody down there at the prison that works for the prison to get them to write you a positive report, sign it, and do all that good stuff. But there's an official form for it. They know what it is. So you get that, boom. As many of them as you can, not just one, get as many as you can. I had a parole hearing one time where a guy had literally 20 work reports. And 10 of them verbatim said that they recommend this person to make parole. So if the person's going to write you a work report, you might as well throw the bug in their ear that, hey, if you're going to write me a work report and you really feel like parole is a good thing and I'm deserving of that, then ask them to expressly provide that, to actually write that in the 1 or 2 sentences where they can say what they want to. Boom. So get you some work reports. That's that. Now, here's where stuff gets tricky for you. Okay, here's where stuff gets hard. Requirement number 4, the inmate must attach a letter of support from at least one of the following. So at least one of the following. And basically, this is going to be law enforcement or the victim, law enforcement or the courts in the county of conviction, or it's going to be from the victim, and each of these in turn. So a letter from the office that prosecuted, a letter from the office that prosecuted the inmate's case, the victim or victim representative, Alabama Attorney General's office, the sentencing judge or his or her successor, law enforcement official from the county of conviction. So, you know, they talking about laws and law enforcement from your county of conviction. So if you caught your case out of Montgomery County, then you got to get it either from the prosecutor's office, the victim or their representative, the AG, the sentencing judge or his or her successor, or law enforcement from the county conviction. So you got to put your thinking cap on, got to get creative here. So if you got family or loved ones that might be a sheriff or a constable or somebody that work at the courts or whoop-de-whoop, boom-de-boom, hey man, exercise your resources. And also your communal groups as well. It might be a church, through the church, that you be able to get one of those letters. You know what I mean? It might be through reentry program or something like that. So just be optimistic and explore all of your resources. Okay, requirement number 5. Here's another tough one. Inmate has not received any violent disciplinaries during his or her present incarceration. So a violent disciplinary is a fight of violent disciplinary. This is prison, right? We know, I ain't never been to prison, but I watch TV. You know what I'm saying? I listen to my clients talk to me, tell me how stuff is, and just understanding the essence of that. To me, that's a bit unrealistic to say that you've never had a fight. Now, I can understand fighting with a weapon, shanking, attempted this or that. Okay, I get that. But a fight, I'm going to fight for you. I'm going to go hard for you. It is what it is. This is the requirement. They say no violent disciplinaries. Okay, be that as it may. Requirement number 6. Has an inmate received any disciplinary of any kind during the 3 years immediately preceding the application. So in other words, are you case free for the 3-year period before the date that you actually filed this application? Totally case free, minor, major, no damn cases. Okay. It's my cuss word for today. I'm sorry, guys. Working. I did good though. I'm 10 minutes, 15 seconds into that thing. You understand me? Okay. Requirement 7, and has the inmate been assessed as low or medium risk of potential reoffense? So again, now here you're looking at your ORAS, also looking at your classification. So you need to be in the lowest custody level possible. And if you're trying to do stuff like early parole or parole in general, like, you need to be thoroughly motivated and about that, everything that it's going to take of you to get your custody level in its best possible condition. So if you got good custody level and you've been staying out the way and doing everything that you're supposed to, that shouldn't be a problem. And if you haven't seen my video already on the Ohio risk assessment, go to my videos, check it out. If you got all that good stuff, holler at me. But in general, I just wanted to make a video so that when people call me and ask me about early parole, it's all here. You know what I mean? It's just a matter of, do you meet the requirements or not? And that's just what it is, shawty. So again, this is Attorney Terry Henderson Peden of the Law Group of THP. My phone number, office number is 334-544-9471. Full writing address below. Don't hesitate. Holler at us. And God bless y'all. Be safe. Peace.